Good afternoon. My name is David Lyle, and I am the Acting Executive Director of the American Constitution Society for Law and Policy. When I wrote out my remarks last night, I planned to call this the most significant event the American Constitution Society had ever hosted. In light of recent events, I suppose I should say that this is now by far the most significant event, most significant ACS event ever, and also our most important undertaking. For now, as the nation prepares for another of its periodic revisitings of our constitutional legacy, the American Constitution Society is pleased to release two new publications that we believe will shape debate on what the Constitution means and how to interpret it. The conversation that begins today will continue in ACS's over 200 chapters in 47 states at our national convention in June, in the blogosphere and in the media. We urge you to join this great debate. The first volume being released today, Keeping Faith with the Constitution, offers an approach to constitutional interpretation that is faithful to the Constitution's words and principles and explains why it is the world's most enduring written constitution. We wish to thank the authors, Goodwin Liu, Pamela Karlan, and Christopher Schrader, for this tremendous contribution. The second volume, It is a Constitution We Are Expounding, Collected Writings on Interpreting Our Founding Document, is an anthology of excerpts from some of the finest existing writing on constitutional interpretation, taken from decisions of the Supreme Court and other opinions and speeches by justices and judges and the scholarly literature. We thank this volume's editors, Pamela Harris and Carl Thompson, and the authors who gave permission for their works to be included. We should also recognize Judith Applebaum, Mira Trahan, and Alex Wohl of the ACS staff, who devoted many hours to coordinating these projects. And I would like to thank Chuck Cooper, a distinguished public servant and lawyer, for joining us today and offering his own deeply held vision of the Constitution. And now it is my pleasure to introduce the moderator of today's event, Dahlia Lithwick, or she is known to some, the queen of all legal media. Dahlia is a contributing editor at Newsweek and senior editor at Slate, for which she writes Supreme Court dispatches. Her work has appeared in the New Republic and the Washington Post, and she has been a guest columnist for the New York Times op-ed page. She is a graduate of Yale and Stanford Law School and clerked for Judge Proctor Hogg of the United States Court of Appeals for the Ninth Circuit. And thanks to the all-seeing eye of Wikipedia, we know, or think we know, that in 1990, she and partner Austin Goolsbee were runners-up for the National Debate Team of the Year. True or false, Dahlia? Okay. I would also add that today Dahlia is under crushing deadline pressure to produce many column inches of her characteristic wit and wisdom on the rumored Supreme Court vacancy. But, mensch that she is, at great personal sacrifice, she honored her commitment to us. Her editors may not be happy, but we are very happy indeed that she is here today to moderate this wonderful panel. Dahlia?
Thank you. I don't know if anyone's ever been called a mensch and a queen in the same bio, but thank you for that incredibly generous introduction, and thank you for allowing me to moderate this tremendous panel. I think one of the reasons ACS has asked me to be here today is because I've been banging on for years and years about the fact that it always seemed as though conservatives could argue that what they did was science when it came to interpreting the Constitution, and it left sometimes progressives to suggest that what they did was some kind of interpretive dance. These volumes are hopefully setting us on the road correcting that, and I commend them to you. They're both tremendous. So on that note, I just want to introduce our panel, if I could, and I'll start alphabetically. I also want to say you've got full bios here. I'm not going to waste your time reading them. I'm going to give you greatest hits, but ask you to read all the bios of all the panelists to begin to do them justice. Starting to my left, Charles Cooper is a founding member and chairman of Cooper & Kirk. Named by the National Law Journal as one of the 10 best civil litigators in Washington, he has over 25 years of legal experience in government and private practice, with several appearances before the Supreme Court, scores of other successful cases on both the trial and appellate levels. He served under Reagan in the position of Assistant Attorney General for the Office of Legal Counsel, re-entered private practice in 1988. He is a member of the American Law Institute, the American Academy of Appellate Lawyers, and has spoken and published extensively on a wide variety of constitutional topics. Seated directly to my left is Pamela Harris of counsel in O'Melveny and Myers, Washington, D.C. office, where she works on Supreme Court and appellate litigation. Her practice focuses on public interest litigation. She's a lecturer at the Harvard Law School, co-director of the Harvard Law School Supreme Court and Appellate Advocacy Clinic. She's also a visiting professor at the Georgetown University Law Center, where she teaches a first-year class in criminal justice. Goodwin Liu, we're all the way down to the left now, is the Associate Dean and Professor of Law at UC Berkeley School of Law. He is also the co-director of the Chief Justice Earl Warren Institute on Race, Ethnicity, and Diversity, a multidisciplinary think tank on civil rights, law, and policy, and he is chair of the board of the American Constitution Society. And finally, right there in the middle, Pamela Carlin is Kenneth and Harley Montgomery Professor of Public Interest Law at Stanford Law School. She co-directs Stanford Law School's Supreme Court Litigation Clinic, which litigates before the Supreme Court on behalf of workers, criminal defendants, nonprofit organizations, and other groups and individuals who otherwise couldn't afford experienced Supreme Court counsel. She's also done extensive pro bono litigation in state and federal courts on voting rights, reproductive rights, and the civil rights of gay people. It is an enormous honor to welcome all of the panelists. And without any further ado, I want to invite Goodwin to start us off, telling us a little bit about this publication, Keeping Faith, and how it started, and where it's going, and what it does.
Sure. Well, thank you so much. Thank you, Dahlia, for being here today, and thank all of you for coming. So this book engages a long-running debate over how we should interpret our Constitution. And for decades, this debate has been framed as a contest between conservatives on the one hand, who urge fidelity to the text and original understandings of the Constitution, and liberals and progressives on the other hand, who purportedly ignore the text and substitute their own values and policy preferences. You'll hear a lot more about that, I think, in the months to come. Well, we enter this debate by addressing a slightly different question. And that is, how have judges, elected officials, and ordinary citizens actually gone about the task of constitutional interpretation? What explains the enduring character of our Constitution in the face of profound social, economic, and political change? And what approach to interpretation accounts for the greatest constitutional achievements of the American people, such as ending racial segregation, securing gender equality, and empowering government to meet the nation's needs? Our basic thesis is that the Constitution has endured because judges, elected officials, and citizens throughout our history have engaged in an ongoing process of interpretation. And where that process has succeeded, it has been because of, not in spite of, fidelity to the constitutional text. And to be faithful to the Constitution, we say, is to interpret its words and to apply its principles in ways that sustain its vitality over time. Fidelity to the Constitution requires us to ask not how its text and principles would have been applied in 1789 or 1868, but rather how they should be applied today in light of the conditions and concerns of our society. Now, to put these claims into a little bit of context, let me highlight three features of the Constitution that really anchor our book. The first is that the Constitution, as Franklin Roosevelt put it, is a layman's document and not a lawyer's contract. In other words, it's a document that belongs to ordinary citizens and their representatives every bit as much as it belongs to lawyers and judges. So it's no accident that public debate and popular movements, such as the New Deal and the Civil Rights Movement, have played important roles in shaping what we understand the Constitution to mean. And it's neither surprising nor illegitimate that judges, in interpreting the Constitution, look not only to original understandings, but also to contemporary understandings of the Constitution expressed in legislation, evolving traditions, and social practices. Public engagement with the Constitution and judicial respect for that engagement is what has enabled the Constitution to retain its democratic authority over time. A second key feature of our Constitution is that its framers repeatedly chose general language to establish basic principles with broader applicability than the specific problems that gave rise to particular provisions. Just to take an obvious example, the Reconstruction Amendments were adopted to end slavery and secure the equal citizenship of black Americans. But the 13th Amendment not only addresses slavery, but also bans involuntary servitude. The 14th Amendment does not mention racial equality. It guarantees equal protection of the laws, and it extends this protection to all persons, not only citizens. And the 15th Amendment's ban on racial discrimination in voting applies to all races, not only the newly freed slaves. So the Constitution contains broad principles that transcend the specific applications motivating their enactment, and that is an important reason why ongoing interpretation, instead of formal amendment, has been the primary way that our Constitution has retained its relevance, legitimacy, and authority over time. Third, our Constitution is not merely an aspirational document or a statement of abstract principle. It's a practical framework for constituting a system of government and operationalizing our commitment to democracy, liberty, and equality. This practical dimension means that the task of interpretation must, as Justice Breyer recently put it, fulfill the Constitution's promises not as a matter of fine words on paper, but in terms of how we actually live. And so it's no accident that constitutional interpretation throughout our history has been responsive to the lived experience of the law and to changes in our society. Time and again, our judges have rejected legal formalisms such as separate but equal in favor of interpretations more closely tethered to the way law affects the lives of ordinary people. Now, if this much seems clear, then it should be equally clear why originalism and strict construction are flawed. Strict construction seems to say that judges should stick to the text and read that text narrowly. But that only gets you so far. Some provisions of the Constitution are very determinate. For example, all revenue bills must originate in the House of Representatives. But the most contested provisions of the Constitution are phrased in general terms. And it simply begs the question to say, follow the text. The important question, of course, is how should the text be applied? How should it be interpreted? Originalism doesn't provide a convincing answer, in part because the original understanding of indeterminate text is often indeterminate as well, in part because originalism can't explain even the most basic constitutional understandings we take for granted, such as Brown, and in part because the framers themselves were not so parochial as to bind future generations to their own specific understandings. Why else did they choose general language in writing the Constitution? The genius of their accomplishment is not that they had answers to every imaginable problem that society would face. It's that they correctly anticipated that the Constitution, written in general terms, would endure and retain its legitimacy through ongoing adaptation and interpretation by succeeding generations. Finally, we are equally skeptical of interpretation based on theories of fairness or justice external to the Constitution. The Constitution is a written text, and its values are stated in that text. So it's the job of judges to interpret the text as it has been applied and understood over time, and not to deduce value propositions from a political or moral philosophy and then shoehorn those propositions into the text. At some level, the temptation to rely on political or moral philosophy is motivated by the same vice as originalism or strict construction, and that is the desire to reduce constitutional interpretation to something mechanical, something formulaic, or something scientific. The reality is that our interpretive tradition, a tradition that has made our Constitution the most enduring written Constitution in the world, our tradition rejects the use of a singular method or algorithm for deriving constitutional meaning. The actual practice of constitutional interpretation by judges of all stripes has always considered text and history, to be sure, but also facts and social context, precedent and experience, practical consequences, and yes, the evolving public values, social practices, and popular understandings of our founding document. So that's how we achieved our greatest constitutional achievements That's why a 220-year-old document with relatively few amendments still speaks to us and inspires our allegiance, and that's what we mean by the title of our book, Keeping Faith with the Constitution.
Thanks, Goodwin. Pam, do you want to continue on the same, in the same vein and about the same text and give us a little background in?
Sure. Well, let me just say to begin what a privilege it is to be here today and how delightful the whole process of writing the book was. There's a line in Alfred Tennyson's poem Ulysses, which many of you know is one of my favorite poems, where he talks about one equal temper of heroic hearts. And I think of what we tried to do in this book in part to become part of that process. And one of the real delights about reading the book when I finally saw the page proofs is you no longer can tell which words in it were written by which one of us. You can tell which words are in the Constitution because the book contains the Constitution and it contains the text as written. But it's just been a terrific privilege to work on the book. Justice Souter is much in our minds today, and he once wrote that the first call of a theory of law is that it should fit the facts. What we try to do in chapters 3 through 8 of this book is to show that our theory of the Constitution and of constitutional interpretation, a theory that keeps faith with the text of the Constitution by looking to its language, but also to its structure and its principles, better describes the facts out there. That is, it better describes the constitutional doctrine that we have and the constitutional doctrine that Americans expect. For example, only our kind of approach can explain how the national government has used and how it's expected and required to use its Article I powers to promote the general welfare. So, for example, in Chapter 4 of the book, we show how the bedrocks of the current American welfare state, things like Social Security or Medicaid, or things like federal environmental laws, can be constitutional only under an understanding of the text of the Constitution that adapts the text's principles to the problems we see today. That popular and congressional understandings of the Constitution as a document that empowers our national government to deal with the contemporary economic crisis are a correct reading of that text and not a repudiation. You can't go around wearing a rubber band on your wrist that says WWJMD for what would James Madison do, or WWJBD for what would Jonathan Bingham do. You have to ask, what do their words authorize Congress and the people to do today? Moreover, an explicit feature of our constitutional design, which is expressly articulated in the enforcement clauses of the Reconstruction Amendments, is a recognition by the framers themselves, by giving power to Congress, that no generation can determine forever, for all time, what words like liberty or equality or the privileges and immunities of citizenship mean. By lodging that enforcement power in Congress as well as in the courts, those amendments expressly provide for democratic understandings to bring our Constitution into the 21st century and beyond. Let me say just a couple of words about judicial decisions for a moment, which is when it comes to judicial decisions, only a theory like ours can explain, without twisting itself into a pretzel, how we got cases like Brown against Board of Education, or Reed against Reed, or Kylo against the United States, and why those cases were correctly decided. Asking what James Madison or Jonathan Bingham or the man in the street in 1791 or 1868 would have thought about racial equality, or would have thought about gender equity, or would have thought about whether the government can use a heat-seeking device to find out whether you're growing marijuana in your basement, will not produce the results that all Americans expect, which are that the Fourth Amendment protects you against unreasonable searches, even if those searches don't involve physical invasion, that the Equal Protection Clause forbids discrimination against women, even though women in 1868 were not yet emancipated, or that public schools in the District of Columbia cannot be segregated on the basis of race, even though the Reconstruction Congress that proposed the 14th Amendment did precisely that. There is, as we say in the book and as Goodwin said, a reason why the United States Constitution has not only endured but thrived for over 220 years, when the average constitution of a nation lasts for only 17. It's because our document has been interpreted not as if it's a piece of the Internal Revenue Code, but as a document of broad principles that are adapted to the times we live in. And so I think that as liberals and progressives, we should stop being defensive about the fact that we have kept faith with the Constitution, and we should make it very clear that the Constitution that we have embodies values of liberty and equality, of rule of law, of access to justice and the like, and empowers our government to deal with our most profound basic needs.
Thank you, Pam. And now we're going to turn to the second text that we're here to discuss. It's the Constitution we are expounding, and Pam Harris is going to tell us a little bit about that.
Well, I also want to start by saying how pleased I am to be here and how grateful I was to have an opportunity to work on this volume. And just very quickly say I'm also very grateful to my firm, O'Melveny & Myers, for making this possible, and extremely grateful to the other lawyers at O'Melveny & Myers who did all the work on the project, including Carl Thompson, who's here today, and Brianne Gorid, who went off to, if you can imagine it, even better and bigger things. She's now clerking at the Supreme Court, and we hope we'll have her back soon. The idea behind this volume, as Dahlia said, is not to create new writings, but to bring together existing writings on constitutional interpretation and try to knit them together in a way that would make them accessible to a broad audience. And the project was very much spurred by the sense that the public debate over constitutional interpretation had become distinctly one-sided in a way that didn't actually do justice to the breadth of views on the question that were out there in academic circles, I think on the bench itself, that the public discourse had become much more one-sided than that, and that it was necessary to revitalize that public discussion, fill it out a little more completely. And what I have in mind here, I think is probably obvious, is the real dominance, again, in public circles of one particular method of constitutional interpretation, which I will refer to as originalism. I know that there are so many different variants on originalism that entire academic careers are spent cataloging each offshoot and branch. What I'll use here is Judge Bork's definition, which is contained in one of the excerpts in our volume. He defines originalism as the position that all that counts when you're interpreting the Constitution is how the words used in the Constitution would have been understood at the time. The only legitimate source of constitutional meaning is what the framing generation understood their text to mean in application. And then around this constitutional theory, I think has grown up a parallel, more political discourse and a more public set of arguments for originalism based on two distinct but related premises. The first is that it is possible to identify with precision and objectively in every case an original understanding that will answer a difficult constitutional question. That originalism is capable, again, in all cases, of providing a definitive and objective answer to constitutional questions. And the second premise, which is argued very vociferously now, is that originalism is the only objective and therefore legitimate source of constitutional meaning. It's only originalism that can constrain the discretion of judges. Basically, if a judge is not doing originalism, then as Dahlia said, he's doing an interpretive dance. She's making it up, legislating from the bench. And I think that is the view that has prevailed in public discourse for a long time now. And the response, again, in public and political terms, has been occasionally something of a deafening silence. And I think it has seemed at times, to at least a casual observer, that maybe there is no response. Maybe there's nothing to be said in defense of any other form of constitutional interpretation. And I think that's just not right. And we can probably all agree that that's not right. That there are people who have been thinking about this for a long time and who have made, again, whatever we think of the merits of the arguments, who have made very good arguments about other methods of constitutional interpretation, have disputed the primacy of originalism. It's been hotly disputed in academic circles, and I think it's disputed by judges themselves, who, as Pam and Goodwin have explained, dispute it implicitly when they actually make their decisions in constitutional cases by resting on methods other than originalism, or at least not exclusively resting on originalism. And as some of the excerpts in the volume will show, judges have also disputed this premise explicitly. They've spoken about it in speeches, they've written about it in articles. There is another way of thinking about the Constitution out there. It's just that it doesn't seem to have penetrated the public discourse. And a big purpose of this enterprise has been to fill that gap, to bring the full debate to the public's attention in a way that's broadly accessible. And we hope that the writings here will show that there is a response to originalism, that there are arguments out there, that there are other methods of constitutional interpretation that do have intellectual integrity, that are intellectually rigorous, that do channel judges' discretion in appropriate ways, and that these methods are not only intellectually sound and workable and consistent with the role of an unelected judge in a democracy, because that's all a little bit defensive, but that they also have something affirmative to offer, a fuller and more robust understanding of the Constitution, of constitutional meaning, one that, as Pam and Goodwin have been saying, keeps faith with the original document, but also makes fundamental principles in that document meaningful across time. And I think the volume can mostly speak for itself on this, thanks to the extraordinary gifts of the writers who are included in that volume. But there is just one point I want to clarify, which is that nobody in our volume is arguing that text and history are irrelevant. Far from it. I think all of our authors would agree that text and the historical context behind it are very important starting points in constitutional interpretation, that they are valuable sources of constitutional meaning. And one reason I am particularly happy to finally have this sort of full discussion is that I think it provides an opportunity to rebut what's almost an implicit assumption in much of this conversation, which is that text and especially history belong to conservatives, that paying proper attention to historical context will always lead to a conservative result. I think that's not true at all. I think, again, as Goodwin and Pam have touched on, that at the crucial moments for the Constitution, the original framing, the amendments, the Reconstruction period, the history behind the Constitution was very progressive in very important ways, and that it's important that the discussion over interpretive method account for this. And so I think we do start from a point of some agreement with originalists in the importance of text and history. But that said, I also think there very badly needs to be a fuller discussion about where you go after that, or in addition to that, about other valid sources of constitutional meaning, things discussed in the excerpts in the volume, like constitutional structure, constitutional precedent, the consequences of constitutional rulings, both on the ground and for the continuity of legal discourse, and things like values and norms that are rooted in the Constitution, that are part of constitutional heritage, but whose meaning may change over time, whose application may change over time in response to changed understandings about what a word like equality really means. And that's the kind of discussion that we are hoping to provoke with this volume.
Thanks, Pam. We now turn it over to Chuck Cooper, who has the unenviable task of responding to all of that in 7 to 10 minutes.
No problem. Well, thank you, Dahlia. And I want to thank also the ACS and the organizers of this event for including me in it to celebrate the publication of this book and congratulate its authors, especially my good friend, Pam Carlin. I am always happy to be invited to ACS events, believe it or not. And you can imagine how privileged I feel to be part of what is by far the greatest event that ACS has ever had, and moderated by none other than the queen of all legal media. And, gee, what timing, you guys. I mean, wow. Now, tell the truth. Was this really just a coincidence? I know you guys are plugged in to Washington currently. Justice Souter's rumored resignation, if it indeed does take place, will bring renewed focus to the running debate over constitutional interpretation. And I do believe that the volume that our distinguished authors here have published now is going to make a very important contribution to that debate. It's very carefully researched and reasoned, very measured, It's among the best defenses of a non-originalist interpretive methodology that I have ever seen, but it's my sad responsibility nonetheless to say that the challenge it makes to originalism, I believe, fails. Now, no issue is more central to our constitutional order than the issue of constitutional interpretation and the competing methodologies for performing that task. To me, originalism is what democracy was to Churchill. It's the worst method of constitutional interpretation, except all the others. Now, I want to begin with and the reason I say that is because it isn't. It does not. I believe it is, frankly, a caricature to say that originalists believe that all of the constitutional provisions provide a determinate and clear and certain answer to any constitutional issue that comes forward. It is certainly true that there are many on which there's simply nothing to interpret, as Goodwin has mentioned. But with respect to those, the issue is what is the meaning of that provision? I would say, what is its original meaning? And its meaning is clear. There's no room for debate. It is true that with respect to the broader, indeterminate passages of the Constitution, that's where issues of meaning take place. But it is my position and my claim here that interpretive challenge too must be guided by the original meaning of the Constitution's textual provisions. And I want to begin with some fundamental, what I consider anyway, to be fundamental postulates. The central premise of our constitutional order, the basis on which the whole American fabric was erected, as Marshall put it in Marbury, is that the Constitution embodies the supreme will of the people and is accordingly a superior paramount law, unchangeable by ordinary means. Therefore, a legislative act contrary to the Constitution is not law. Again, most of these phrases I'm taking from Marshall himself. And to ensure that paramount and permanent law may not be mistaken or forgotten, the Constitution is written, and it establishes a rule for the government of courts as well as of the legislature. Now, Marshall there was echoing, of course, number 78 in Hamilton's observations that the Constitution embodies the intention of the people and therefore must be regarded by the judges as a fundamental law, binding until the people have, by some solemn and authoritative act, annulled or changed it. And it follows, Hamilton said, that where the will of the legislature declared in its statute stands in opposition to that of the people declared in the Constitution, the judges ought to be governed by the latter rather than the former. So I do believe that the sole justification for empowering judges to review the constitutionality of laws and to void laws when deemed inconsistent with that paramount law is that the Constitution is the supreme law of the land, and its central purpose is to constrain and to limit the policies that elected democratic legislatures can enact. But if the judges aren't bound by the original meaning of the Constitution's textual provisions and are instead free to apply a constitutional interpretation that is guided by some contemporary standard of decency or evolving social norm or some ideal of human dignity, then it must surely follow that the legislators and the executives of government are likewise empowered to do that. And why would the Constitution prefer the unelected judges' judgment about prevailing standards of decency or ideals of human dignity to the judgments of elected legislators? So the doctrine of judicial review of Marbury against Madison, I do believe, can only be defended on originalist grounds. For I believe originalism is the only interpretive methodology without a political agenda. Now, the judge who is not bound by the original meaning of the text of the Constitution invariably ends up looking within himself or herself for that meaning, substituting his or her own political views or social values or assessments of the prevailing social norms or the norms that should be prevailing in our society, and substituting those constructs for the views and the essentially rules of law that were ratified in the text of the Constitution by the people themselves. Champions of non-originalist theories of interpretation, especially nowadays, emphasize that originalism can't be legitimate because it is incompatible with certain precedents that are now widely accepted and even cherished in this country. And we've heard Goodwin especially make that point previously. Now that is the key thrust, a key thrust, as I read it anyway, of our author's publication. And this is how they put it in the publication. Neither originalism nor strict construction has proven to be a persuasive or durable methodology, not least because they cannot explain many of the basic constitutional understandings we now take for granted. Now, I do not think that it is true that a serious originalist case cannot be made for any of the decisions that are usually paraded in support of this argument. But I certainly acknowledge that there are some that were very likely wrongly decided from an original meaning standpoint. There are some that I believe were wrongly decided. There are many that I'm not sure really whether they're wrongly decided or not. I can't go toe-to-toe with my constitutional scholars here in examining those issues. I simply haven't done that kind of study. But whether or not that is true, I think ironically that is this attack on originalism that confirms its legitimacy and disqualifies or raises grave concerns and reservations, at least to my mind, about all other non-originalist methodologies. A judge's fidelity to the Constitution, I submit to you, is never tested, really, until it hurts. Until the judge disagrees with the result, perhaps even loathes the result that appears to be prescribed by the rule of law at issue, the rule of law that controls the outcome. All non-originalist theories of interpretation, whether called living constitution, judicial pragmatism, consequentialism, minimalism, the natural law theories of the libertarians in service of newly formed economic rights, active liberty, by whatever name. I believe that all non-originalist theories are ultimately designed to spare the judge that pain, to free the judge of the original meaning of the Constitution and of a obligation to search as carefully and as objectively and as honestly as the judge can for that rule of law in that original meaning, and to apply it, and to free the judge of that obligation so that the judge can apply a rule of law more congenial to the judge's own policy views or social values. Let me give you a couple of quick examples. Take Chief Justice Earl Warren, namesake of your center, Goodwin. he coined the marvelously liberating phrase, evolving standards of decency. It was unknown to the United States reports before that time. Warren would often interrupt oral argument and ask counsel, yes, counsel, but is it right? Is it good? And there's simply no doubt, at least in my mind, that this was the standard that guided his constitutional interpretations. I ask, did Chief Justice Warren write a single opinion or even cast a single vote that one might have reason to suspect was contrary to the way that he would have cast it were he a legislator? I think the same questions can be asked of Justice Brennan, who in a famous 1985 speech ridiculed the search for the Constitution's original meaning. It is arrogant to pretend, he said, that from our vantage we can gauge accurately the intent of the framers on application of principle to specific contemporary questions. And he continued, the ultimate question must be, what do the words of the text mean in our time? What the constitutional fundamentals meant to the wisdom of other times cannot be their measure to the vision of our time. And the vision in our time, according to Brennan in that speech, was a sparkling vision of the supremacy of human dignity of every individual. Now, I also believe that Justice Brennan never authored an opinion, and I don't believe he ever cast a vote. That hurt. And I don't think that is keeping faith with the Constitution.
Thank you. We're going to, in a very few minutes, take questions. Before we do, we want to give the panelists the chance to react to each other. And I want to give the panelists a chance to react to what they just heard. But maybe just in the interest of expediency, I'll fold in another question, and you can answer them both at once, or you can tag team. But the question I have, and again, layered against this very pragmatic reality that we may be watching a confirmation hearing very soon, is just to sort of, I think, press Chuck's point, which is there's something very comforting to the American public about watching a confirmation hearing in which a jurist promises to do very little. And words like umpiring and calling balls and strikes and humility and minimalism and modesty are very attractive. It seems that the nut of the criticism of so much progressive jurisprudence is that it's uncabined, it's unconstrained, and that even though progressives, I think, like progressive results, and Doug Kendall's done interesting polling that say progressives like progressive results out of courts, what they don't like is watching a confirmation hearing where somebody says, here's all the neat stuff I'm going to do. So I wonder if you can react to the problem of how do we cabin? How do we get away from the concern that a judge with a progressive agenda is just going to do what they would do as a legislator?
Just one quick thing without answering the whole question. I mean, what we really know about the American public, and I've read Doug Kendall's polling results too, is that when they were actually confronted with a judge who got up in front of them at a Supreme Court confirmation hearing and said, I'm an originalist, and let me tell you what that means. We don't know the exact numbers, but when Judge Bork said that, a large portion of the American public sort of got off the train and said, I don't think so. The last time we actually heard someone come to a confirmation hearing and defend originalism as sort of a theoretical matter, because I think Judge Bork, and I want to give him full credit here, I think there's always been a distinction between originalism as sort of an academic theory and originalism as a political position. And Judge Bork was an academic, and he believed in an academic theory of originalism. And when he had to explain it to the American public, complete with all of the implications, the American public really didn't like that either. So I just think we should keep that in mind when we think about what kind of a confirmation hearing is appealing to the public. Sorry, it's a minor point.
No, that's fair. Does anyone want to react to this constraint problem?
I'll say one or two things. First of all, I appreciate the very intellectually serious and rigorous look that Chuck has given us on the book. It's hard, actually, to... I'm surprised you enjoy these things, Chuck, actually. Sort of come and be cannon fodder for the rest of the three of us.
I consider it my moral obligation because I am equally hard on you guys when you come visit me at the Federalist Society. So
That's fair. That's fair. I want to say just a small point about the feeling the pain point, which is just to say that certainly that criticism shouldn't be unilaterally directed at justices like Warren and Brennan. I don't know how much pain Justice Scalia feels in his own applications of originalism, especially when he decides that it doesn't apply. When I read the Crozon opinion, I don't exactly feel the pain that Justice Scalia has. In fact, there's no originalist inquiry whatsoever into whether or not the framers of the 14th Amendment thought that racially conscious benefit programs, especially for African Americans, would survive the meaning of the Constitution as enacted. And in fact, there's a good amount of evidence that the Congress of that time, the enacting Congress, thought that there was no problem with such a thing. But there's no evidence of that whatsoever in the writings on that particular issue. So I just give that as one example. But that's not really, that's sort of just a small point about consistency. The bigger point, I think, is that what we're putting forward, I think, should not be understood to be a opening for judges simply to do whatever they want. In fact, I think if you look across our history, the method that we talk about, especially this point about taking into account the evolving social understandings of the people and how people understand the Constitution, has served in many instances to be a constraint on judges rather than a license for activism. And the biggest example I think I can give of that is the New Deal. Because what was happening during the New Deal? The New Deal period was marked by an activist judiciary that was striking down the democratic enactments of the people, that sought to expand notions of commerce beyond what Clarence Thomas would say the notions of commerce were in the 18th century to mean simply barter and exchange. Well, barter and exchange didn't characterize the 20th century economy and certainly doesn't characterize our 21st century economy. And so eventually what happened was that the court yielded to those democratic understandings of those 18th century phrases to encompass something more. And the court then exited the stage so that democracy could prevail. And I think the same thing could be said in the civil rights era, where what Congress was doing was exercising its Section 5 power to say that this is what we understand the guarantees of equality and equal citizenship to mean, and here's some legislation to make that real. During Reconstruction, you remember, the court was in the business of striking down those kinds of legislation. And in the civil rights movement, once again, the court yielded to democracy. So in many ways, I think what we're talking about is a notion of constitutional interpretation that doesn't view courts simply as kind of hermetically sealed institutions that turn a blind eye to what's going on out in the world. Looking at what's going on out in the world, in many of these instances, serves to constrain judicial discretion, not to enlarge it.
Can I just say a little bit about the feel the pain point? One of the justices that Chuck didn't mention, perhaps because he was very explicit about the extent to which he felt the pain of what the Constitution did, is the justice for whom I clerked, Harry Blackmun, who several times wrote in opinions, look, if I were a legislature, I would not do this. But I am a judge, and therefore I see nothing in the Constitution that gives me a warrant to toss this out. And he said that for many, many years until he became convinced that the death penalty couldn't be constitutionally applied in America, that however much he loathed the death penalty, it was his job as a judge to enforce it. He said that about some of the criminal sentencing, and I think that would be true if you looked at liberal judges today who take a view that the Commerce Clause power of Congress is quite broad, and therefore they will enforce what they consider to be savagely stupid drug laws and criminal penalties, because that's what the Constitution gives the Congress the right to do. And let me just say one other thing about originalism, and we're going to see this, I think, with the current Supreme Court in some of the stuff that happened this April, which I think may go down in history as the cruelest month in some ways. And that is, if we ask, what did the Reconstruction Congress and what did the framers of the 14th Amendment think about the Civil War and about the South? They thought it was just fine for the federal government to go in and occupy the South and reconstruct it and to stay there until they got it reconstructed. And what we saw at the Supreme Court 2 days ago in the oral argument in the Muddo case is a bunch of the justices saying, well, we think the Civil War is over. We don't see any reason to treat southern states as if they got it wrong or the like. Well, that might be an appropriate position to take, but you cannot take that as a matter of the original public meaning of the 14th Amendment, because the original public meaning of the 14th Amendment was Congress would have the right to guarantee racial equality in the United States. And the people who promulgated that amendment gave Congress that right in part because they did not trust the court to understand what racial justice meant. And so if we're going to be originalists and original public meaning people, that's an area where I think that the conservative members of the Supreme Court should back down. But I guarantee you they're not going to back down there. And the same thing just in a totally different light. If we look at the D.C. Guns case from last year, which is the D.C. Guns case, both sides talked about what the original public meaning of the amendment was. But let me just read you a little tiny passage from Justice Scalia's discussion of what the word arms means in the Constitution, right? Because the Second Amendment says it's the right to keep and bear arms. And he says, some have made the argument bordering on the frivolous that only those arms in existence in the 18th century are protected by the Second Amendment. We do not interpret constitutional rights that way. Just as the First Amendment protects modern forms of communication, and here he cites a case about the internet, and the Fourth Amendment applies to modern forms of search, and here he talks about thermal imaging devices, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Now, why is that? Because he understands that the word arms stands for a principle about the right to self-defense. Now, whether I agree with the bottom line or not in the D.C. Guns case, it's clear both sides talked about the original meaning. There isn't an originalist and a non-originalist position. Both sides talked about grammar. Both sides talked about what the man in the street, either in Washington or in Boston, would have thought in 1791. Both sides talked about pragmatism and about the consequences. Right? That's why even though Justice Scalia thinks you have a right to keep and bear arms, not in a federal courthouse you don't. Right? Because of the consequences for that. And that's true even though the Supreme Court knows that the First Amendment does apply in the courtroom. Cohen against California says that the First Amendment applies even in the courthouse, but not the Second Amendment. Why is that? Because of the consequences. And so part of our point in the book is just everybody uses a method that looks at all of these issues. And so we should stop arguing as if the method is going to determine the result, rather than how people balance in individual cases the various forms of understanding the Constitution, its text, its structure, the history, the shared understanding, and the way that the Constitution has developed over time. We're not doing anything different in that sense than they are. We're just doing it better.
I'm guessing you want to react to that?
If you don't mind.
I don't want to.
Just a couple of points that stick in my memory from this. One, Goodwin mentions the New Deal and the Lochner era that basically that preceded it, and the New Deal court. The Lochner court, the pre-New Deal court, is a perfect example of the kind of non-originalist judicial activism that at least I condemn. Even though it yielded what, at least to those justices and to their supporters at the time, were very conservative results. And there is a very, there's a, I was going to say respected, but there's at least a body of work and thought that attempts to revive Lochner even now, and I believe it is quite non-originalist. And I don't really understand the argument that the New Deal court actually operated as a restraint on social norms or the application of evolving economic theories. To the contrary, I think it gave them the rein that the Constitution, by and large, gives them. There are some cases I probably disagree with in that regard, terms of the breadth of the Commerce Clause. But I certainly don't understand how the methodology you're advancing operated there at that time as a restraint. Justice Blackmun, I certainly didn't identify him as among the, kind of exhibits A or B. Well, the truth is he, at the time in his career, when he did ultimately, when his growth was complete, or very nearly complete in office, I think it is a fair thing to say that he no longer adhered to the originalist restraints that, at least with respect to the capital punishment, and I believe other things, had previously given him the kind of pain that I am here advancing is a necessary incident to the role and the obligation of the judge. He ultimately did become satisfied, notwithstanding what I think is the determinate and clear authority for application of capital punishment. He did ultimately free himself, I believe, of the bonds of the original meaning of the Constitution. And so, while I wouldn't put him as Exhibit C, Pam, I do believe that he grew in office in a way that was unfortunate. I want to make one final point, I guess, about Heller and the notion that originalism doesn't make room for application of the enduring principles that are discoverable in the original meaing of the Constitution's text for advances, technological advances especially, which is the context that I think Justice Scalia was speaking about in Heller, and certainly it's the context that he was relying upon in the Fourth Amendment area and others. The principles of the Constitution were indeed designed to endure, to be immortal, and to be applied to new circumstances and things that the founding generation didn't and couldn't possibly have foreseen. And that is especially poignant with respect to our technologically advanced society. But I thought also it was quite interesting that both the majority and the dissent proceeded from originalist premises in very careful, thoroughgoing analyses of what the text of the Second Amendment meant to those who had proposed and framed and ratified it, how they understood what it meant. And it demonstrates that originalism is not something that is mechanical or formulaic. It is tough. It doesn't spit out an answer like some mathematical equation when you plug in the variables. And there is room for disagreement about how one assesses the evidence of that meaning. There's also room for distorting it and abusing it. It's like any other interpretive enterprise. But I was struck by Heller from that standpoint, because both the majority and the dissent did certainly proceed from those kinds of originalist premises. Thank you.
I don't want to beat a dead horse, but I just had one more thought about the feeling the pain question. And I sometimes wonder whether, when we think about someone like Chief Justice Warren, and did he ever feel the pain, whether we almost have by now a stunted sense of what the legal choices really are, what is a liberal legal outcome, and whether we sometimes almost think circularly, well, if Chief Justice Warren came out that way, that must be as liberal as it gets, whether we're reasoning backwards a little bit. Because I think of Chief Justice Warren's work mostly in the criminal procedure area, and I think of some of his biggest decisions like Miranda and Terry. There is pain all over those pages. I mean, the Chief Justice in Miranda I think we now tend to think of Miranda as an extremely liberal decision, but it fell well short of what was being argued in that case, which was not that you have a waivable, I don't want to get too technical, not that you have a waivable right to counsel when you're interrogated, but that there can be no station house interrogation without a lawyer. The court didn't go there, and I think the pain of that is actually pretty clear on the face of the opinion. Same with Terry. The argument was, you want to seize someone, you want to frisk them, throw them up against a wall, you better have probable cause. Court said, no, that's okay, reasonable suspicion will be enough, and the pain of that is all over the pages in Terry. And so I worry that sometimes when we look back, particularly at the work of the justices in the 60s and the 70s, there's almost an inclination to assume that must be as liberal as it gets. That's not right. I think that we've stunted the spectrum of legal thought in a way that removes the possibility that there could have been more progressive readings of the Fourth Amendment and the Fifth Amendment. And I know this area best, but I would assume that the same is true in other areas that are covered in your book.
So we're now at the point where everybody's arguing about who feels the most pain, which is, I think, a good place to stop and take some questions. Now, there are microphones, right, that are there and there. And I'm going to ask, before you ask your question, which is going to come, please, in the form of a question, that you identify yourself and where you're from. So if folks have questions, just put your hand up and we'll get a mic to you. Okay, right here.
Hello, Bob Ritter with the Appiani Humanist Legal Center. I'd like to address this to the whole panel. I feel a lot of pain in keeping faith with the Establishment Clause, that is, the current court. And I was just wondering what your thoughts are. For example, the case coming up probably this fall, Salazar versus Biono, and whether or not it's permissible to have a Christian cross on public property or engage in sham transactions to keep it there. Thank you.
Well, I think that the Establishment Clause is one area where the court itself has always been very historically rooted in the way it thinks about the clause, where everyone has been an originalist, if you will, and that position has, at least for a long time, led to some results that might be described as liberal. I don't think that's quite right, but that have been very protective of individual rights. Through that kind of originalist prism, we know, a sense that we know what the founders were about when they put the Establishment Clause into the Constitution. The historical context, that's one area where the historical context really was rather progressive. So for me, this is an area a little bit like what Pam was talking about with the Second Amendment, or I'm sorry, the Voting Rights Act, where if you're going to be an originalist or call yourself an originalist, profess to a commitment to original understandings, this is one area where you should be reaching some outcomes that are very protective of individual rights to dissent and to be free of even non-legal forms of coercion in the religious area. And so for me, the question will be, where will these professed originalists come out in a case like that, where a fair reading of the history, I think, would push them in what sometimes looks like a liberal direction?
Well, I really don't agree with that assessment. I don't know anything about the case you're referencing, but at least my impression of the Court's Establishment Clause jurisprudence has been that it has, with just a couple of exceptions fairly recently, been always very closely divided, usually 5-4, and usually pursuing a drive of eliminating all religious references from the public square. I argued Lee against Weissman, which was a case involving a rabbi's invocation at a public high school graduation. And the court there decided 5-4 against the school district that I represented. And no surprise, I'm sure, that I don't think the court got that one right. And I think the history of the generation that founded, that framed and proposed and ratified the Establishment Clause is very hard to square with with the notion that the utterance of the word God in a public graduation ceremony is somehow an establishment of religion. This is the same group of founders who opened their own legislative days, which is the case to this day, with prayer. So anyway, I think there's a lot of room for debate in terms of how the outcome of these cases would be determined from an originalist standpoint.
Right, I was going to say, I think this is really a perfect example because the Supreme Court itself thinks it is being an originalist. It does. In the original precedent from the 60s and 70s, they believe that they have accurately divined the original, so to speak, the original understanding behind the Establishment Clause, behind the Free Exercise Clause, and that points them in the direction that culminates in Lee versus Weissman. They think they're being originalists, and this may be one of those examples where it sort of shows that originalism, it's not an objective enterprise. It's necessarily going to require the kind of judgment calls that leave room for considering things like contemporary values, for considering precedent, for considering practical consequences, which is, I think, what Chuck was saying before, that it's not properly understood as a purely objective mechanical enterprise, and that people of goodwill are going to come out different ways on what the founders really had in mind.
I do believe that.
Next question, right here. Yeah, you. Okay.
Hi, Ken Thomas, Congressional Research Service. I'd like to ask a question that I hope isn't just going to rhetorical language, but and perhaps the whole panel could address this. But Mr. Cooper, when you use the phrase unelected judges, I always find that interesting because, of course, historically there are very few elected officials in the United States government, the House representative being really the only direct representation. And, of course, Supreme Court justices have long tenure, so that perhaps makes them unique too, but that's not to say that people with long tenure in our Senate or in our House somehow are delegitimized by that. So I guess I'd just like to say, is the phrase unelected judges really just a rhetorical phrase, or is there actually some political or other reason why the fact that judges are unelected somehow might delegitimize their abilities or their position?
Well, I think the a fundamental premise of our democracy and the work of our legislatures, including the guarantee clause, is that democratic majorities have a right to decide for themselves the laws that will govern them. And so by operation of the democratic process, which is a difficult process, bicameralism, presentment to the president, and ultimate constitutional review if there's a reason for question, is what gives those laws legitimacy in our system, in our democracy. We don't allow the president to issue ukases that govern America, and so when you have the work of a democratic body being reviewed for its consistency with a higher law, a paramount law, at least in my judgment, I think in the framers' judgment, that body, that group of unelected, appointed, life-tenured judges, needs to be tolerably confident that paramount law does indeed forbid the work of the representatives of the people themselves, because that is by definition in our system legitimate, unless it's unconstitutional.
Wait for Mike. Hold on.
I'm Chris Philpott in private practice here in Washington. What was the nature or the history of this debate prior to 54 or the New Deal courts? Well, I'm sure it existed, but did it have the tenor and purposes that the debate seems to have now?
You know, this debate took place in a very similar way at the time of the New Deal. You had New Deal giants like Robert Jackson. Oh, I'm sorry. Forgive me. Yeah.
It seems to have started when Rights for Others expanded. I'm not sure about the history of the debate of the discussion at all prior to that time. And then, of course, it seemed to have really developed following 1954.
The first time, at least that I'm aware of a debate of this kind, at least among Supreme Court justices, and my scholars to my left here could certainly stand to correct me, is in Calder against Bull, when Iredell and Chase argued over whether or not the court was free to apply natural law as found by the majority of the Supreme Court. I believe that it was Justice Iredell who believed that the court was free and obligated to apply natural law principles, even if they went beyond the original meaning of the text of the constitutional principles before them. I think that was an ex post facto case, but honestly, but if there's an occasion where this basic issue was debated before this on the Supreme Court, I don't know about it.
I mean, you're certainly testing the limits of our historical knowledge. But I would say that, one interesting thing that we found in researching this book is that the term strict construction actually can be found all the way back to Gibbons and Ogden in the early 1800s, in which Chief Justice Marshall is writing an opinion about the Commerce Clause, and there's a passage in there in which he says, gentlemen, meaning counsel, contend for a strict construction of the term commerce, and he rejects that. And he says that that's not the nature of a constitution, is that, the Constitution was meant to be an adaptable instrument for times to come. And this, I think, goes to a broader point that I wanted to make in response to what Chuck said about his very first point about the supreme will of the people being reflected in the Constitution. I think that there is no quarrel with that. I think that is certainly correct. But the framing of it, I think, is just slightly off in this way. The way of talking about the Constitution as reflecting the supreme will of the people and laying down an intention to bind future generations is much the same way we talk about statutes. And those of you who have read Justice Scalia's book, A Matter of Interpretation, know that that is the argumentative pattern that he uses, is that he first criticizes the unwillingness of what he perceives liberal judges to follow the letter of statutes and instead to substitute common law notions of fairness or justice in the place of reading the text of statutes faithfully to the legislator's intent. And then he makes the move to extend that argument to constitutions. So it goes from statutes to constitutions. Now, as a matter of statutory interpretation, I don't think there's any, you're not going to get much disagreement about the idea that the fundamental controlling aspect of how you read a statute is what is the intent of the lawgiver, the legislature. And the text is the primary source for understanding that. But Marshall, I think, was very careful in the McCulloch case especially to say that the Constitution does not partake of the prolixity of a legal code. It is not, as Pam said, a piece of the Internal Revenue Service provisions. Rather, he says, a Constitution is an instrument to be adapted to the crises of human affairs. It marks only the great outlines of what the society is supposed to be. And so necessarily a Constitution is different from a statute because the lawgiver is not intending to bind future generations to any specific set of understandings that may have been encompassed within the language at that time. And that was Marshall's view, and that, I think, as we try to trace throughout the book, has been the consistent view throughout our history, and that is in our view, the explanatory factor for how it is that this very old document has managed to stay with us and still command our reverence despite all the changes that our country has been through.
Hi, I'm Ian Milheiser with the National Senior Citizens Law Center, and I want to ask a chicken and an egg question, which is, I think, implicit in the very existence of this panel is the notion that the ideas in these books have power, and that, you know, we will come up with ideas, and then these ideas will actually change the country that we live in. And there's a similar debate about the past. You know, one says that Robert Bork wrote a law review article, and the theory of interpretation that he came up with was really powerful, and that changed the way that judges decide cases. But the other theory is that Nixon and Reagan had a product that they sold, and people wanted to buy what they were selling, and once they got elected, one of the consequences of that was that people who happened to be originalists got appointed. So I guess what I'm looking for is a defense of the notion that the ideas in these books are, in fact, the cause, and the future presence of progressive judges who will reach progressive decisions will be the effect, and that things aren't going to go the other way around.
I have plenty of delusions of grandeur about our book. I mean, if that's the question, I mean, that's my answer. I think you ask a very perceptive question. In some ways, our book is an odd polemic because one way of reading our book is to say a lot of these debates are kind of academic in the sense that if you look at what people actually do, it's not easily categorized as sort of originalist, non-originalist, in this way. And I think you've heard a little bit about that just in the exchange up here. I think, you got to understand this debate at several levels. There's the level of descriptively what people actually do as judges. And obviously I'm more in agreement with Pam, with what Pam Carlin just said, which is that, Heller is the good example of where, the judges, I think all 9 of them are not debating methodology. I mean, it's true they pay close attention to text and history, and that is certainly the starting point. Chuck is correct about that. But I would say that when you read that stuff, it seems to me they argue almost to a draw on the text and the history. I'm certainly not historically trained enough to be able to judge who has the better of the historical argument. I mean, given the amount of stuff that they looked at, I mean, who could be confident one way or the other about that? So instead, one has to look at other things. And the fact that they looked at other things is not in and of itself something illegitimate or something to sort of raise a question about. That is just what judges do. I think that point to me is, I'm persuaded of that just from our historical review. The other level, though, at which this debate occurs is a more political level, which is what are the labels given to what judges do to achieve certain outcomes that legitimize them as an intellectually sound and principled thing to do. And I think it's partly at that level that we hope to make a contribution to say that, these attacks on so-called liberal or so-called progressive judges for somehow violating an important canon of interpretive fidelity, right, are misplaced because even the professed adherents of those methodologies don't do that. And that's not the way it's ever been done, really, truly, throughout our history. And if we want to keep the things that we most cherish about our constitutional understandings, we won't do it that way in the future either. So it's at that level, I think, that we hope, not in the level of sort of changing things, but rather in the level of the legitimacy of the perceived legitimacy of what people are doing.
Well, and I think there's also part of the importance of the book is it's not written primarily for judges. This is not a handbook for judges about how to decide particular cases. Rather, it's an opportunity for us to talk to citizens and to legislators as well about how do they think about their constitutional responsibilities. Because I think for far too long it's been assumed simultaneously that a very narrow form of original public understanding dictates the answers in various cases, and that the appropriate decider to quote the former president, that the decider decides these things and that the decider is always the Supreme Court. And a central message of our book is that when it comes to a lot of the phrases in the Constitution, the text of the Constitution itself, as well as our history and the original understanding, gives the public an important role in deciding what these things are. So the public is supposed to have an important role in deciding what equal protection of the laws means by electing the Congress that decides how to enforce that clause. That a lot of the Constitution is not about what goes on simply in the courts, or it's about how the courts, far from striking down the public and popular understandings, ratify and approve them, so that I don't think any of the authors of our book would have said that the Supreme Court, faced with the problems of the Great Depression, could have ordered a social security system into place and said, well, there are lots of Americans who are starving and they're elderly and they all deserve a pension, so we're going to find somewhere in the text of the Constitution a right to give people pensions. But the Supreme Court was required to say that Congress could have decided, using its spending clause powers and using its powers under the Commerce Clause, that this was appropriate legislation. And so I think part of our book is an attempt to say that understanding what the Constitution means, reading the document, and I think the first chapter of the book goes through the document pretty carefully and talks about the text and how the values that we care about as liberals and progressives are in the text. And not, you have to play the text backwards and it'll tell you Ringo is dead and, by the way, equality is good. But it's in the text, right? And so a lot of this is, I think, an attempt to not just reclaim the arguments about constitutional methodology, but to reclaim the Constitution as a document that embodies in its text our fundamental values, and not to let ourselves be kind of pushed around by the idea that in 1791 people wouldn't have believed in gender equality, or they wouldn't have believed in any kind of economic redistribution or the like.
What does the Constitution say when you play it backwards?
I had a friend who used to read the Fourth Amendment backwards and said it made about the same amount of sense in both directions.
What it says is, obey the original meaning.
Actually, when I read it backwards, it says, Chuck Cooper is wrong. But this is the problem. This is why you have to stick to the forward reading meaning of the text.
I want to just footnote a thought that inspired by Goodwin's remarks, and it comes back to your question about unelected judges and elected representatives. It is certainly possible, as you suggested about Heller and the original meaning of the Second Amendment, that you can have a constitutional issue that comes to honest, careful, conscientious judges, and they do pretty much find it to a draw. And it seems to me, and so it's possible that there are constitutional provisions that don't answer questions that come to the court. And I think that, at least to my mind, means that if a judge can't conclude with some level of confidence that the constitutional provision does not permit that which the legislature, the decider, in most cases, almost all cases, has done, then the judge should defer and should not look to other things. Well, some other things outside of the text itself and all of the evidences that can be called to account to try to discern what that original meaning was. What was that rule of law? Was it an individual right of American citizens to possess a gun in their own homes for self-defense? If the answer to that is a draw, then it seems to me that the legislature has to be free to say, we're going to restrict your ability to do that. Now, I want to hasten to say, I don't think it was a draw. I thought Scalia had the better of it, but I'm making the point of what it seems to me the conscientious judge's obligation is when the Constitution doesn't answer the question.
If I can just add on to that, I mean, I think that seems like an appealing approach if you're thinking about constitutional interpretation solely as a matter of constraints on judges. What are the constraints? And the constraint is you're an unelected judge, going back to the question, and you shouldn't overstep your authority in a democratic system by striking down a democratically elected law if it's a draw on original understanding. But what I think it overlooks is that judges do have constraints on them, but they also have affirmative obligations in our constitutional system. They are affirmatively obliged by the Bill of Rights, I think by the original structure of the Constitution, but certainly by the Bill of Rights, to protect the rights of individuals, to protect liberty interests and equality interests when they are abused by a majoritarian political process. I think it's only half a theory of constitutional interpretation to think about constraints on judges. You also have to think about their affirmative obligations. And there, I think, if you're fought to a draw on original meaning, judges are not only allowed but affirmatively obliged to look harder at other sources of constitutional meaning to make sure they are doing their entire job, not just the constrained half.
We've got time for one more question, and I sort of vaguely see, are you there under the light?
Yes, Kenneth Jost with CQ Press. Two questions, both dealing with the same issue for two different sides of this debate. Professor Liu, you said something about yielding to democracy, which would seem to say that the Constitution is not merely living but kind of fickle. It changes from one generation to the next, and I wonder if that's what you meant, that Plessy might have been right when decided and Brown is right when it was decided. And from the contrary perspective, Mr. Cooper, in what instances does the Democratic majority have to yield to a constitutional command?
Goodwin?
Okay, well, let me just clarify what I meant about yielding to democracy. My only point in saying that was that I was drawing the example of the New Deal period, in which the methodology that takes into account the evolving political, social, and economic conditions of the country caused the court to yield to democratic understandings of, I mean, if you want to put it in constitutional language, commerce, or more broadly, of federalism, if you want to talk about it structurally. But the point is that prior to the New Deal, the court had been sort of interjecting itself to stymie, essentially, the legislative efforts that President Roosevelt had been trying to muster to get the economy moving. And eventually, I mean, of course, scholars debate this period about the exact motives and legitimacy of the switch in time and all of that. But the basic point is that the settlement achieved through the New Deal, which is that the courts would exit the stage when it comes to economic regulation, has been with us and stable and deeply accepted. And I mean, obviously there are people who still question it today, but for the most part, deeply accepted for the last 70 years. And so that doesn't mean the Constitution changes. I think all that means is that the way that the democratic process, which, as we've been saying, is a legitimate player, not just the courts, but the democratic process, a legitimate player in interpreting the Constitution. Those understandings have a kind of those understandings are due the respect that court decisions have, and court decisions are right to look to those democratic understandings in informing what they do. Let me make one last point about, you said Plessy and Brown. That's a very interesting question. Was Plessy wrong at the time it was decided? Well, of course Plessy was wrong. You look at Plessy itself, and Plessy said that, you know, if African Americans feel stigma from segregation, well, that's just the construction that they choose to put on it. One of the worst lies ever said in the United States reports. So there's no question Plessy was wrong. It's a more difficult question, though, when you think about a lot of these hot-button culture issues that we face. You know, 50 years ago, I don't think anybody would have said, if you ask people, is gay marriage unconstitutional? Are laws denying gay marriage unconstitutional? I think that the broad consensus across the political spectrum would have been, no, there's not really much of an argument for that. The fact that it is more deeply contested today, I think, is sort of testament to the interpretive approach that we are advocating. And it shows the way in which the equality guarantee of the Constitution is inflected with the social understandings of people. It's a direct analogy to draw between that issue, say, and gender equality. How did we get gender equality jurisprudence in this country? Not because the original framers of the 14th Amendment thought the 14th Amendment even protected women. I mean, the laws of coverture were not even thought to be disturbed by the 14th Amendment, whereby the woman's identity was fused with her husband upon marriage. So there's no way on original understanding that you could even explain how we got gender equality in America. And so that evolutionary process we see in a variety of other issues that we face, we're in the thick of right now. And all we try to say in the book is that there's nothing wrong with that. That's the way constitutional development occurs, and that's the way we've managed to achieve the greatest achievements we have as a people.
Thank you for that very easy question. I think that, and I mean that because I think the best answer is the one provided by Hamilton. And that is, whenever the will of the legislature declared in its statutes stands in opposition to that of the people declared in the Constitution. That's when elected representatives have to yield to the Constitution. Obviously, that begs the question that we are here now debating, and as we've already noted, sometimes that's very easy. If a senator introduces a revenue bill, that's, that can't stand, and nobody serious would dispute it. I very well remember when the Congress was debating whether to give President Clinton a line item veto. Senator Byrd and Moynihan and Levin and several others were quite satisfied that that doesn't consist with the Constitution. I agreed with that. It had been my tough obligation to tell President Reagan that when I was in the Department of Justice, and it was not advice that was particularly easy to give or that was very well received. But and because he very much wanted to exercise a line item veto, and I very much wanted to find a way to permit that. I very much supported it, and I ended up representing, along with some other very fine lawyers, the senators in a constitutional challenge to the line item veto, because the structure of the Constitution requires bicameral passage and presentment of the president, and that's that. And the Supreme Court, a divided Supreme Court, agreed with that. But that's the issue is easy to, for me anyway, as an originalist, to state. It's not easy to do.
I have to thank the panel for what has been an incredibly nuanced and sophisticated debate about something that I think, as Pam Harris suggested, has sometimes not been a debate at all, has been a pretty one-sided discussion. I can't wait to hear the tape of this played backwards. And I want to say that this is an extraordinary moment for these two volumes to come out, because I suspect that sooner rather than later, this is a debate that's going to be happening on cable news and on radio and in the op-ed pages. And so I really want to thank ACS for inviting all of us, thank the panelists for their exceptional work today, and to thank all of you for coming.